Good afternoon to everyone. We have too many registrations this time, and it was at the last moment yesterday. We only extended our package, and instead of 500 participants, now we can have 1,000 participants. It is just 4 o'clock as of now, and we have 360 participants as of now, and it is rapidly increasing because most of the people were in waiting, and the moment we started, they would be getting in. This is a wonderful experience to me that all my professional friends, my banker friends, entrepreneurs, they responded so well to this webinar of mine, which is a very, very hot issue these days. Insolvency and bankruptcy vis-a-vis SARFAESI Act. We would like to wait for 3-4 minutes more, because I can see that as I'm speaking to you, it has already touched 400, and people will take time in joining in. But then it is not really good for us that we should skip their 4-5 minutes initial discussions. As you all understand that I've been sharing my experiences with all at various forums, and I like to do this because this is also my way of learning. I have learned so far in this manner while going to pre-registration courses of insolvency and bankruptcy, while going to Indian Institute of Corporate Affairs for the GIP program, while even I'm going to the training centers of various banks. Besides this, we are also very, very busy in our own profession, the profession of enforcement agent and resolution agents under SARFAESI Act, and the profession of insolvency and bankruptcy. So I'm trying to find time for all of you, and I would be continuing with these kind of webinars. And the only objective is to share my experience and whatever, also to improve my own learning. Whenever a question is asked from me, I normally introspect whether I know that answer or not. But if I don't know that answer, then I try to find answer at home, so that in future when somebody will ask questions to me, I would have the accurate answer till that time. So friends, we are now almost touching 500. Since the capacity is 1,000 now, it was increased, and our registrations have reached, because the registration had to stop in between. We had to stop the registration because it touched the maximum of 1,250 yesterday morning. But then we increased it today morning, and now we had the registration capacity of 2,500. So we have more than 1,300 registrations, and participants are joining very, very quickly.
Hello.
I would like to be with them.
Yeah, hi. Is that Rahul? Rahul, आपका नंबर मेरे को अनुभव ने दिया है, तो हमारा जैसे कुछ
Today also we have seen that the IBBI has come out with the new regulations, and those are simply giving us further relief from timelines which we may not be able to comply with because of the lockdown period. My understanding about the lockdown is that it might even continue for longer. It may become part of our life. We might have to live with this, maybe in a different form, the economy will start on a restricted and with precautions. It is not possible to close the economy forever. The solutions will be found, and the different lifestyle will be developed, different working environment will be developed, and the way we are doing work from home, and especially at AAA, I think most of us would have to do that. The difficulty that we faced was only physical movement of staff, physical movement of various other stakeholders where it is required. But once the physical movement is open to some extent, it would be really good to work like this. We somehow in the last 1 month have developed the habit of working like this. If the physical movements are started, then this way of working is much better. We could find time to introspect ourselves. We could find time to look into the standard operating processes, into our companies, into our businesses. And we found that a lot of training has happened during this period. This is a good time that we could use and avail for various developmental activities. So friends, let us start now. It's already the time that we have close to 600 people participating as of now, and still it is increasing very fast. Friends, like the seminar that I perceived was the webinar that I perceived was a overview of SARFAESI Act, overview of Insolvency and Bankruptcy Act, and comparison between the outcome of two. See, this scenario in the economy will continue like this. The stressed asset with the banks would increase, and there would only be two options available with the lenders, with the creditors. One option would be SARFAESI Act, and the other option would be insolvency and bankruptcy. The third option, which may be helpful in near future, is the RBI circular dated 7th June 2019. And that would be only for restructuring of corporate stress or even other entities. The fourth thing that we are expecting is maybe some bailout package will come and the government will try to give some kind of relief to all those entities, all those businesses who have suffered loss in this lockdown period. And there may be a process of assessment, doing assessment for those losses. There may be a process for understanding the actual loss incurred by any business, any entity, and then extending that financial help to that entity, maybe with some subsidy and maybe with some interest relief. This content that we are making for the SARFAESI, for insolvency, and for comparison between the SARFAESI and insolvency, the content is very large, and I just don't want to do a webinar which is just elementary approach or a kind of for a beginners. I know that the audience that we have who have registered with us, they're all professionals, they're all bankers, they're all entrepreneurs, well-settled people. They would not like to have elementary knowledge. They would like to have in-depth knowledge or in-depth understanding along with the practical experiences. Therefore, we have decided that today would be chapter 1 of the subject, and it will be focusing on the SARFAESI Act. I will actually go into the importance of SARFAESI Act just in a moment. Then we will have chapter 2, and in case we are able to finish in chapter 2, then we will also have the comparison between the SARFAESI and the insolvency law. See, we have been allotted by the banks and NBFCs and ARCs cases to the tune of 27,000 under SARFAESI Act. See, we act as the resolution agent or enforcement agent, or some banks even call us supporting agency. And we are only taking cases which are under SARFAESI Act. Our role is to, right from the beginning till the sale of the asset. However, most of the documents are signed by the authorized officer of the banks. There are processes, there are teams working on this across the country. We have our human resources across about 81 cities in the country for SARFAESI actions. So this way, this webinar on this subject may conclude in 2 sessions, one chapter 1 and the other would be chapter 2. In fact, I have already circulated a mail saying that the chapter 2 of this webinar, which would be insolvency and bankruptcy and comparison between SARFAESI and insolvency and bankruptcy, that would be on Wednesday, again same time, that is starting at 4 o'clock for 2 hours. And in case we would be able to finish that in these 2 chapters, that would be fine. In case we would not be able to finish that, then we might have even the 3rd and final chapter, so that the concept, so that the various issues under these 2 laws are clear to participants. So friends, as I said, this SARFAESI is very, very important as of now. Reason is the insolvency and bankruptcy is primarily suitable to companies under operations, larger companies, whereas the SARFAESI is applicable to everyone. It is applicable to the home loan defaults, loan against property defaults, working capital, term loan, various kinds of defaults. Maybe it is default by an individual, by a partnership firm, by a society, by a trust, or a company or a LLP. Everywhere the SARFAESI is applicable. So the SARFAESI is much larger in application, much larger in the area covered as against the insolvency. So anyone who actually is trying to understand the how to manage default, maybe if some of the entrepreneurs are thinking that in case of default, what would be my rights under SARFAESI Act? That is also very, very important. And the banks will also kind of understand what are their obligations and what are their rights under the SARFAESI Act. So when we say that, I would actually be using some language which is suitable to both. One is the defaulter, or the other would be the lender. So I would actually give the remedies, rights, duties, obligations of both sides, because this webinar is not for one segment of stakeholders. It is for everyone. So I think now we can start. Already the number of participants have actually gone very high. So we can start the understanding about the SARFAESI. I can start with my screen, and if I share my screen with you, yes, I am sharing my screen with you now. Ankit, is it okay with you? Screen is visible to you?
Screen is okay.
Screen is
so the screen was okay. You will have to share it again. It was earlier appearing. It is now disappeared.
okay. So then I would only simply
Now it is
remove
perfectly
myself
fine.
from the.
Now it is perfectly fine.
Yeah, it is okay. It is okay. So I have to just remove myself from the screen, my own screen. So I have to just hide my webcam. Okay. So friends, this we'll start with the SARFAESI, and I will just go through my slides. So as you know, this webinar is for this. So the beginning of the SARFAESI law in this country started in 2002. So the larger name of this act is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. It came into operations on 17th of December 2002. See, it has seen a lot of litigation in the first 1 year, and finally, in fact, more than 1 year, and then finally the Mardia Chemical, a very famous case of SARFAESI law, and in that case, the Supreme Court provided some guidelines, and based on those guidelines, then the removal of difficulties order dated 6th of April 2004 was brought by the central government. See, along with the Act, the Securities Interest Enforcement Rules 2002 was also notified, and in fact, the rules were there from 20th of September 2002. Going forward, we have seen amendments in 2003, some guidelines by Reserve Bank of India, and then there was some securitization and reconstruction of financial assets and enforcement of security interest central registry rules. The central registry rules, in fact, was made in 2011, and the central registry was set up also almost at the same time. It was set up on 1st of April 2011, which we call in short SARFAESI, and that's what is central registry. Then this amendment, one of very important amendment came in SARFAESI Act, that was in 2016, and that amendment in fact was also notified in phases. There are some sections was notified in 2016 and some was notified gradually. Then we also have seen for the other amendment act. The latest that we have also seen the Security Interest Enforcement Amendment Rules in 2018. This also brought some significant amendment. So when we see this SARFAESI law, there are three parts of this SARFAESI Act. The first part is, which is Chapter 2, and it is from Section 3 to Section 12, which is which provides the entire law in this country for the registration and monitoring of asset reconstruction companies, and the powers were all given to RBI. How the asset and reconstruction company would be acquiring the rights in the financial assets of the banks and financial institutions, that was also handled by this chapter of the Act. How the assignments of the debt would happen. See, like it was like maybe that somebody is wondering that today I have signed all the documents, like as a borrower, I have signed all the documents with the bank or with the consortium of a bank or with the, and then suddenly the one bank or the consortium, they have assigned the debt to an asset reconstruction company. So I have not signed it. See how the asset reconstruction company is proceeding against me. So that is what is provided by this law, the Chapter 2 of this law. Whenever any asset reconstruction company will acquire any financial asset from banks or financial institutions, the acquirer, that means the ARC, will step into the shoes of the bank and financial institution without even taking any signature or any fresh documentation from the borrower. So that part was handled by this Chapter 2 of this Act, starting from Section 3 to Section 12. We are not dealing with this part because this is belonging to the this is pertaining to ARCs. They are monitoring by the RBI their internal processes. The next part is the Chapter 3, which is from Section 13 to Section 19, which is called enforcement of security interest. So this is what we are concerned. This is what we are deliberating today. Enforcement of security interest means that security interest is that all that asset on which any bank or any financial institution has a charge or a hypothecation or a pledge, all those assets are collectively called as security interest, any kind of security interest, and enforcement. So enforcement of security interest is completely is provided in section in Chapter 2, Chapter 3 of this Act. Why this? Although the sections are not many, but this Act has seen a lot of litigation, and I think, if you compare to the number of sections and the kind of litigation that this act has seen, I mean, there is no comparison with any other act like this. The enforcement of security interest, the basic objective of enforcement of security interest was to, because the problem of bad debts was very high in 2002 and before that, and the government thought of bringing some expeditious process which actually will facilitate banks and financial institutions to recover their money faster. So this was the first time that without the intervention of any court or any tribunal, the banks were able to enforce their security interest. The banks were able to enforce their pledge, hypothecation, and any kind of security interest. So the third part of this law was Chapter 4. In fact, Chapter 1 provides for the definitions only. So that is the reason Chapter 2, Chapter 3, Chapter 4 are actually basically three parts of the law. So Chapter 4 deals with the central registry, which is SARFAESI, which was set up in 2011. And in fact, in this particular law came in 2002. The central registry was set up in 2011. In fact, it was set up on 11th March 2011. Central Registry of Securitization, Asset Reconstruction, and Security Interest of India. In short, it is known as SARFAESI. So these are the three parts of this SARFAESI law, whereas we would be dealing with only Chapter 3, which is dealing with the enforcement of security interest in case of default. So there were, like we have seen this amendments also. The SARFAESI Act, the 2016 amendment is considered to be significant, which was implemented in phases. 36 sections were implemented on 1st September, and then 3 sections were notified on 4th November. Then recently on 20, we have seen on recently on 26th of December 2019, the 3 more sections were notified, and they were effective from 24th January 2020, because 1 month period was given to all the banks and financial institutions and embassies to get their transactions registered on SARFAESI, because after this 24th of January 2020, it is not possible now to invoke SARFAESI Act unless the transaction of creation of charge is registered with SARFAESI. So this is very, very important that this amendment came right in the last couple of months back on 24th of January 2020. So we'll go back to the detail of what was notified in January 2020. So the constitutional validity of the SARFAESI Act was also a very big litigation. It has actually seen a lot many litigation. The first was, of course, Mardia Chemical, and finally it had gone to Supreme Court, and Supreme Court suggested some of the processes that has to be taken care by the lenders, and some of those actually came as an amendment act in 2004. Of course, this the constitutional validity was also handled by Siddhi Vinayak Hotels Private Limited, Rameshwaran Cotton Industries Gujarat Private Limited. So, like the primary issue in this particular constitutional validity was that without any court, without any tribunal, how do we protect the borrowers? Any lender can use some atrocities, so there has to be some kind of backup for such atrocities, such unfair practices which some lenders might even follow. So that was the apprehension, and there is another apprehension in this was even the property is being sold and there is no right to appeal in this act. So all this was very, very serious issues which actually was handled in multiple court cases. And then the very, very important case was like the banks started going to take possession of the properties, and they found a tenant there, and the tenants were evicted, and then gradually the tenants were protected in various cases. And one of the very important case in protection of the tenants' right is Indian Bank versus Nippon Enterprises. So these are the constitutional realities and some significant cases. Now, we also have to see if the SARFAESI Act can be used by everyone. No, SARFAESI Act can only be used by secured creditors, and not all the secured creditors, but defined secured creditors. The definition of secured creditors is given in Section 2 of SARFAESI Act, and which includes banks, financial institutions, maybe it's a consortium of bank or individually or whatever, or even consortium of financial institution. Asset reconstruction companies, of course, was initially included into the list of secured creditors. However, in the case of secured debentures or debt securities, the debenture trustee appointed by the bank or financial institution, debenture trustees who are registered with SEBI, and if they are appointed by any company for secured debt securities, they are also eligible to use SARFAESI Act for the recovery of the recovery of their security interest. Any other trustee holding securities on behalf of the banks. Originally, non-banking financial companies was not part of the secured creditors. Later on, the NBFCs were also made part of the SARFAESI Act. In the definition, they were added. The secured creditors were added by way of a notification, and the first such notification came. Of course, whenever there is a debenture which are unsecured, then it is only the SARFAESI Act is only applicable to the secured assets, security interest, secured creditors, and see, like, it is not applicable to anything which is unsecured, neither unsecured debentures or neither unsecured loans. So the recovery process, it is a recovery process by just sale of security assets. Nothing otherwise. There is no otherwise. In case it has to be a recovery, then it has to go to the RDB, Recovery of Debts and Bankruptcy Act, 1993. That would be the appropriate act for recovery. So on 5th of August 2016, the government notified 196 NBFCs, and they notified these NBFCs as financial institutions. And what was common in all these NBFCs, that all of them had assets more than 500 crore as per their last balance sheet. This they actually were notified as financial institutions as per Section 4 of the Companies Act. In that manner, 196 companies were allowed to invoke SARFAESI only for those cases where the debt is 1 crore and above, whereas the limit for banks, financial institutions, asset reconstruction companies is 1 lakh of rupees, whereas the amount of debt for NBFCs which is eligible for invoking and taking the benefits of SARFAESI Act was kept as 1 crore. However, very, very recently, that is on 24th of February 2020, the Ministry of Finance again gave a notification to provide again some relief to the NBFCs, and the limit of 1 crore was reduced to 50 lakhs. And one thing which is very, very important, that all those NBFCs who are having assets worth 100 crore as against 500, now the limit has actually been reduced to 100 crore as per the last balance sheet, audited balance sheet. All those NBFCs would be able to use the provisions of SARFAESI Act for enforcement of their security interest, for taking possession, for sale. All that was done. Now, the present scenario is that all the NBFCs are allowed to invoke SARFAESI actions in the following cases, where the single loan is 50 lakhs or more with security interest on an asset, where the multiple loans aggregating in one name is 50 lakhs or more and the single asset is charged. When the multiple loans with multiple assets with cross charges on each other for 50 and which goes above 50 lakhs or more, multiple loans aggregating 50 lakhs and multiple assets having no cross charges, but the borrower is the same. In all these cases, the NBFC now can enforce the provisions of SARFAESI Act for recovery of their debt. As I said, the security interest. Normally, in our common parlance, we use the asset is hypothecated, asset is pledged, asset is charged, a lien is created, a pledge is created. So various kind of nomenclatures that we use wherever we are saying that there is a charge created by the lender on any asset which may be owned by the borrower or anybody else who actually is doing that. So the definition of security interest is again provided in Section 2 of the SARFAESI Act, and the definition is as regards the tangible properties. As regards the tangible properties, it includes mortgage. Mortgage is normally applicable to the fixed assets, charge, hypothecation, assignment. So this is kind of applicable to the immovable properties. Any right, title, or interest of any kind, that is also part of the definition. Now, like hypothecation, when we talk about hypothecation, it is all charges except a pledge. Hypothecation is also called floating charge. SARFAESI can be invoked for sale only after crystallization of assets, that is, after taking possession. Now, I will give you some of the examples of hypothecation. See, when we take a car on loan, the car is hypothecated to the bank who has given loan to buy this asset. The SARFAESI Act cannot be invoked till the time the car is taken possession. So because it's a floating asset, the floating asset, we can invoke SARFAESI Act in case we take the possession. So first we take the possession of this kind of floating assets, and then we invoke SARFAESI for sale. Because this is the act which provides powers to bank to transfer title ownership of an asset to a bidder. The asset presently belongs to, say, a borrower, maybe land, building, plant and machinery, car, vehicle. So when it is the SARFAESI is invoked, the SARFAESI Act gives powers to the bank's authorized officer, that the bank's authorized officer can issue a sales certificate without even taking any permission from the owner of the property, and the buyer or the bidder of the property would get a good title. That is all because of the SARFAESI Act, that any property is owned by somebody else and it is being sold by somebody else. So hypothecation is also there in the case of stocks, in the case of even receivables. So when I say my stocks are hypothecated to bank, that's a floating charge. And when I invoke SARFAESI, first of all, I'll have to take the physical possession of the stock. So once I take the physical possession of the stock, then only the SARFAESI is applicable. Then only I would be able to invoke SARFAESI for sale of the asset which is now in my possession. I'm coming back to the pledge. Pledge transactions, see, like in most of the pledge transactions, the assets are already in the possession of the creditor, secured creditor. The pledge is actually governed by Section 172 of the Indian Contract Act. So on pledge transactions, the SARFAESI Act is not applicable, because see, the SARFAESI, the pledge is otherwise. I will give you some examples of pledge. The examples of pledge is like by stock is pledged to the bank, and the stock is kept in a godown, and the bank has got a lock, and the bank releases me this stock, then only I use it. And it is very, very popular in the agricultural commodities, where you might have seen various silos when you travel on the highways, and those silos are now being used for holding stocks of agricultural produce, and later those silos are mortgaged to the bank, and the key of the silos always remains with the bank. So the bank releases after taking the payment. So this is the pledge is also not covered under SARFAESI Act, because it is again already the possession is with the with the bank or with the lender, and the power to sell is already with them. They don't need, they may invoke SARFAESI, but then they don't normally invoke, because why to invoke SARFAESI? Otherwise, the jurisdiction goes to DRT. Right created by way of financial lease, hire purchase, conditional. So this was also added in Amendment Act 2016. Earlier, hire purchase transactions, lease transactions were not part of the SARFAESI Act. But now these are part of the SARFAESI Act after the amendment in 2016. So regarding intangible assets, it is like right, title or interest, assignment by way of security or not assignment, license created on the properties, any kind of intangible properties, maybe receivables, maybe licenses, maybe any other thing, wherever this SARFAESI can be, this can be done. This has to be all the above, all this pledge, hypothecation, all the above must have been created in favor of the secured creditor to secure. Credit provided to enable the borrower to acquire the asset. So this is where we call term loan, or where we call hire purchase, or we call lease, where the money given to the borrower is used to acquire the asset, maybe tangible or intangible. Second is the obligation to pay any unpaid portion of the purchase price. That is also kind of disbursement, and this is called working capital also. Any obligation incurred, license of intangible assets, all this is like with respect to various kind of intangible properties where the SARFAESI can be used, where you also can pledge licenses, you can also pledge your intangible properties, all that can be invoked under SARFAESI action. Now let us understand what is all not enforceable under the SARFAESI Act. I mean, there is a section 31, which is a common section after the chapter 4, and which provides an exclusion, that in following kind of transactions, the SARFAESI cannot be used for enforcing the security interest. Now, my first part is lien. A lien is a right of retention with no power of sale. Whenever I have a lien on something, I normally have a right to retain that item, but then the power of sale is not there unless I take the consent or I take the order from any other thing. So these are the lien part is handled by the Contract Act, Indian Contract Act 1872, and some of the examples are bailment, margin money, earnest money deposit, lien on fixed deposits for providing loans, lien on shares for providing loans, factoring services. So agents lien on principal's property. These are all section 170, 171 and section 221 of the Indian Contract Act. So let us understand, in all these situations, there is a lien on the asset, and the asset is already with the person. Maybe it's a margin money. When I buy shares, I give some margin money to broker, and the broker keeps a lien on that margin money. And whenever I default, the broker adjusts that margin money, because he's already taken a consent letter from me while he was getting the documents. Similarly, when I take loan from the bank against my fixed deposits in the bank, that's a lien created by the bank on the fixed deposits. And whenever there is a default, bank doesn't need to invoke SARFAESI. Bank will simply use that documentation that I have signed, take out that document where I have consented already that you can use that document for even premature of the deposit, for adjustment, for debit or credit transaction in your account. So all these are the lien transactions. So there is no requirement of invocation of SARFAESI provisions for default in the case of lien. Then coming to pledge. In the case of pledge, the lender has already a power to sell. Whenever there will be a default, the lender will be able to sell. So in these cases also the SARFAESI is not applicable. Like, let's understand, it is all again on regarding movables, movable items, movable securities. This is covered by section 172 of the Indian Contract Act. So this is not something that we can enforce under SARFAESI Act. So the good example is pawning. Somebody comes to me with the jewelry or with the gold and take some loan from me. That's called pawning, and any kind of asset which can be given to someone as a pawning contract. There's a pledge by mercantile agents also, that is also covered as a pledge of goods for loan, pledge of agricultural produce in silos, old ground system. In case there are some participants today with me who actually have seen old godown system, when there used to be a stockkeeper or a godown keeper in the banks, and that stockkeeper or godown keeper would used to go to the earmarked godowns in the factories, in the units, where all those stocks would be kept which are under pledge with the bank. So those stocks, the bank already have a right to sell. Bank doesn't need SARFAESI. Bank cannot invoke SARFAESI actions. Whenever there will be default, the bank or NBFCs or any financial institution will be able to enforce their right of sale. So the SARFAESI Act is also not applicable on aircrafts, because the aircrafts are also those are managed by the Aircraft Act 1934. SARFAESI is also not applicable on vessels under the Merchant Shipping Act 1934, because the default and the recovery in all these assets are handled by Aircraft Act or respective act. So the other part is there is a under the Sales of Goods Act, Section 47 says regarding the right of unpaid sellers right on the goods till the time the delivery is not been given. That right remains with the seller. So that is also outside the ambit of SARFAESI. Property is not liable to be attached. See, we have seen like there is a section 60 under the Code of Civil Procedures 1908. Under that section 60, any judgment debtor, whosoever is having any decree against him, there are certain items which are excluded from decree. So like the personal items of human need, wearing apparels, tools, utensils, some kind of house, pension fund. So on those assets also SARFAESI cannot be enforced. And the other, which I said already, any financial assistance which is less than 1 lakh, the SARFAESI cannot be invoked. Now comes the most important part of it, is the security interest created on agricultural land. All this agricultural loan are not covered under SARFAESI. These loans are not enforceable under the SARFAESI Act. However, it has this part of the law also have seen a lot of litigation. There has been numerous judgments on this. What is agricultural land, and what would be considered as an agricultural land, and this is I will discuss in a moment. So the other very important part is that where the total outstanding amount is less than 20% of the principal amount and interest. Now, in case I have taken a loan of 1 crore rupees and today my balance outstanding is only 15 lakhs, and if I default, the bank or financial institution cannot enforce SARFAESI action, cannot take away my asset from me. So that is because my total outstanding is 20%, which is my total outstanding is only 15% of the principal amount that I borrowed, including even interest. So my total outstanding is 15 and it is less than 20 lakhs. So I would not be having the fear of getting SARFAESI actions against me. So there is a confusion so far, like whether these vehicles, motor vehicles or two-wheelers or four vehicles, those can be covered under the SARFAESI Act. There is no bar. Most of the public sector banks, they use SARFAESI for taking physical possession. So basically, first the physical possession is taken, then under SARFAESI they sell that. But most of the private companies, the NBFCs, the private banks, they are using this Arbitration and Conciliation Act 1996 because they already have a clause in their agreement, and they immediately get that Arbitration and Conciliation Act order, and based on that order, they take police help and they take possession of the two-wheeler or four-wheeler or whatever is the vehicle. So the hypothecation of motor vehicles, SARFAESI Act is also used, and for some faster action, it is not being used by the private banks. In the kind of recovery of motor vehicles, there is a very famous judgment of in this judgment, the Supreme Court held that the lenders have to be human when they go and take over the possession of the assets. And based on this order of Supreme Court, then RBI came out with the guidelines for all those recovery agents who took physical possession of the assets, specifically all those recovery agents who take who recover money or who take physical possession of movable items. So these judgments, this judgment of Supreme Court finally became guideline for RBI to come out with the guidelines which are supposed to be adhered to by recovery agents, by people who take physical possession. And then RBI also came out with a course that anyone who is supposed to be engaged in recovery business, they have to undergo a course. And most of the recovery agents are actually doing that course, so that they should know before they join the course that these are their responsibilities and they have to do that job with responsibility. So there is a concept of negative lien, which is just a restraint on the sale of the property. And mostly it is only in those cases where the title deeds of the property are not such that a valid mortgage, maybe equitable mortgage or registered mortgage is created. When no kind of mortgage can be created, then the banks normally go for negative lien. Let us take an example, like there are various properties in Delhi NCR or even outside in India where the conveyance deed or sale deed is not available, or even the lease deed is not available when the property is leasehold and still mortgageable. What I'm trying to say is that in those cases, mostly we have seen that the banks take all the original documents from the borrower, along with the documentation and assurance that the borrower will not sell this property without taking consent of the bank. So this is a negative lien. This is a negative lien on a property. So on the negative lien, since it is not a mortgage, it is not a hypothecation, so this is not covered under SARFAESI Act. So for all negative lien, the SARFAESI action cannot be taken. SARFAESI action can only be taken when the hypothecation mortgage is created. On the agricultural land, it has actually seen many litigation, much bigger litigation regarding the agricultural land. Most of the borrower, they were taking the arguments in the court that their industrial plot is also an agricultural land. I will give you some examples. There are many areas in this country where if you want to set up a factory, there is no the conversion of land use required. There is no CLU required. And especially in the case of older factories, those were set up just by acquiring an agricultural land and then setting up the factory there. And none of those properties have actually got the CLU. So in the records of the Tahsildar or in the records of the Patwari, that land still continues to be agricultural land. In most of those in most of those cases, whenever SARFAESI Act was being invoked, most of the borrowers, they took they took the argument in the court that this is an agricultural land. Then there are many judgments, and the Supreme Court has actually come out with a judgment named as Binoy Kumar Saharoy, and the saying that the sense of the word tilling or plowing of the land is important. It was also held that simply that land revenue is being paid, that does not establish that it is an agricultural land. In most of the cases, it was found that the Patwari is still continuing with that entry into Fard and Gurdori as an agricultural land, whereas the factory is existing on that particular plot for the last 20, 30, 40 years. But the Patwaris are still continuing with that land as an agricultural land, and still they are registering the Gardaris and Fard. Of course, whatever I'm saying, speaking in different states, it would have different names. One is the record of the ownership of the land, and the other is the record of the uh, crop on that land. Who is the owner of the crop and who is the owner of the land? These are the two records which is maintained by Patwari or Tahsildar. One is called in northern India Fard, and the other is called as Gardori. So it was also held in a very important judgment that the business of seafood is not an agriculture, but on the other hand, the cardamom cultivation, it was considered as an agriculture. The rubber land planted with rubber be treated as an agriculture land, and SARFAESI Act cannot be invoked. See, these were some of the disputes regarding agricultural land, but now it is much settled. I have seen over years the borrowers are not taking this plea now in the court that it is an agricultural land, because apparently if the land is not agriculture, apparently if the not actually tilling and harvesting is not being done, the agricultural land argument would not sustain. So the financial assistance is also defined. So there are three aspects of very important wording in the SARFAESI law. One is that uh, secured asset. What is the asset? And this the one is who is the secured creditor, means the bank or financial institution, and the third is the what is the financial assistance. So this is a slide which I am showing that these are the financial assistance. In case the financial assistance covers under this definition, then this is a case where the SARFAESI can be invoked. Otherwise, SARFAESI cannot be invoked. Like loans or advances granted or acquired. When I'm saying acquired, that is applicable for acquisition of cases like ARC acquires or ARC takes assignment. Debentures or bonds subscribed or acquired later. Even if we acquire a debenture or acquire a bond from market, if those are secured, those definitely the SARFAESI action can be taken on this financial assistance. Guarantees given by like bank guarantees, letter of credits, these are all again enforceable under SARFAESI Act, but because they get converted into financial assistance, the moment bank guarantee is invoked or the LC is devolved, they get converted into financial fund-based assistance. Any fund provided for acquisition of tangible asset under financial lease, hire purchase, or conditional sale is also covered. Funds provided for obtaining assignment or license of intangible assets is also covered. Purchase of debt securities or subscription to debt securities is also covered. So there is another line which says any other credit facility extended by the bank or financial institutions. So this makes the definition inclusive, and the only thing that we have to fulfill two conditions, as I said in the beginning, that secured creditor should be eligible, the security interest should be eligible, and the financial assistance should be eligible. So I repeat the three basic tests for invoking SARFAESI. One, that the financial assistance should be as per the definition, the secured creditor is covered and eligible under SARFAESI Act, and the security interest is also eligible to be invoked under SARFAESI Act. I'm giving on the right side of my slide, I'm giving some of the financial assistances which are not covered under SARFAESI. For example, the discounting of bills of exchange, hundis, factoring services, transactions of pledge, pawning, pledge of goods, these are not covered. These kind of financial assistances are not covered under SARFAESI. Now since we have seen three basic ingredients of SARFAESI Act, secured creditor, security interest, and financial assistance. Now we actually go ahead and see in case the financial, all these things are, in case all these things are covered, then we see now we are fit for invoking SARFAESI Act. And now let us understand, in case we invoke SARFAESI Act, then which is the adjudicating authority? So adjudicating authority for SARFAESI is the debt recovery tribunals. So the uh, present situation in the country is that we have 39 benches in the country located across India at 22 locations. Recently, the government has also implemented EDRT. However, the pendency is high in various benches, and I also been hearing that there is a high level of vacancies in the benches. So that may be one of the reasons that the effectiveness of the DRT and the disposal is not been faster. The government tried to take some action in September 2018 when they increased the limit of DRT. They increased the limit of DRT from 10 lakhs of rupees to 20 lakhs of rupees. Now, in case our loan outstanding is less than 20 lakhs, we cannot go to DRT under the RDB Act. So this was also done so that this tribunal should be more effective and facilitate faster disposals. The government is also trying to improve the infrastructure at DRT and DRAT, as I have seen that the central government announced unified cadre for the staff at all DRTs across the country, and that came as notification dated 8th of June 2008. Sorry. See, like I just share with you my experience a little bit because I was going to different DRTs for providing them understanding about the individual bankruptcy, which is applicable only for personal guarantors so far. So I went to give this presentation to a couple of DRTs, to a couple of members of the DRTs, to the presiding officers. My observation was that the DRTs were not very enthusiastic about handling this new, they have the new obligation now, the insolvency and bankruptcy law with respect to the personal guarantors, and only for those cases where the corporate debtor is not under NCLT. So this infrastructure has got debt recovery appellate tribunals. There are 5 appellate tribunals in India, which is in Delhi, Mumbai, Kolkata, Chennai, Allahabad. And presently, the debt recovery tribunals and the debt recovery appellate tribunals has got 2 jurisdictions. One is the Recovery of Debt Due to Banks and Financial Institutions Act 1993. I just would like to share with you that this particular name of the act has been changed now. It has been changed to the Recovery of Debt and Bankruptcy Act 1993. And it was changed with effect from 1st December 2019. Why was it changed? So when this Insolvency and Bankruptcy Code came in 2016, there was a clause that was not notified, and that clause also contained, because it was seen by those people who drafted the IBC that this DRT court would be used for bankruptcy of individuals also. So they thought it appropriate that the name of this court, the name of this act should also be changed, because the proceedings in DRT would be handled under this RDB Act. So this particular section was notified on 1st of December 2019, and now the act, which is earlier it was the Recovery of Debt Due to Banks and Financial Institutions, now it is called the Recovery of Debt and Bankruptcy Act 1993, with effect from 1st December 2019. So the other act, SARFAESI Act, is under the jurisdiction, and the third act, which is now having the jurisdiction before DRT or the DRAT, that is all those cases of personal bankruptcy who are personal guarantors to any corporate, and that corporate is under default. If the corporate is with IBC under liquidation or under CIRP, then that case of personal guarantor will be handled by the same bench where the corporate debtor is being handled. So in case the personal guarantor is defaulting for a company which is not under IBC, then this case will go to DRT. So the DRT has a jurisdiction for some of the cases of personal guarantors for bankruptcy and insolvency. Now we have seen the three basic ingredients. We have also seen the adjudicating authority. Let us now try to see when SARFAESI action can be initiated. The SARFAESI action can be initiated whenever there is a default. So the borrower makes any default in repayment of secured debt or any installment. The second very important condition is that the account of the borrower has been classified as NPA, non-performing asset, and the Bankers Book Evidence Act 1891 will prevail as far as the evidences are concerned. However, in case of the debt securities like debentures, bonds, secured debt and secured debentures and secured bonds, there is no requirement of NPA. Default is a default. Secured creditor can enforce security interest without any intervention of the court. This is the original objective of the SARFAESI, that no intervention of court is required for enforcement of security interest. This is in contravention to Section 69 or Section 69A of Transfer of Property Act. The security interest created, as I said, that the security interest, secured creditor, financial assistance, three conditions that we have to see. We also have to see that this Section 31, because our transaction is not covered under Section 31, which is the exclusions. So there are two separate things that I wanted to tell you, is that the Section 35 of the SARFAESI is just like Section 238 of the Insolvency and Bankruptcy Code, which is a overriding clause on other laws, and it is again it's a non-obstante clause of the SARFAESI. The other thing is, which is the SARFAESI action can also be initiated concurrently with the DRT application or decree from civil court. So there has been judicial pronouncements that if a lender is going concurrently to DRT and also taking SARFAESI action and also going to any civil court for a decree, it is considered possible. Now, after looking into all this, let us understand what is the step-by-step approach for initiating SARFAESI action. And we now go to step one. So whenever bank decides, whenever an authorized officer decides, authorized officer is also defined under the SARFAESI Act, that the officer has to be a officer of the rank of chief manager, which is normally scale 4 or above. Those are the officers called authorized officers under the SARFAESI Act. If the authorized officer takes a decision that the SARFAESI Act has to be invoked, so the first step is that the secured creditor, means the bank or financial institution, will give notice of 60 days. This is called demand notice, a very popular notice. Many litigations have actually been there on this notice, and this notice says that within 60 days you are supposed to pay your full liabilities to the bank, and in case you don't pay that, then all the rights of the bank or the financial institution under Section 13(4) would be exercised. That is what is the notice, and it should be a 60 days notice. There is a huge, see that the rules are very large. Under the rules, how this notice would be given, how the notice would be served, how the CHASPA would be handled. All this is prescribed to the minutest details. And still, despite providing all details, we have seen, as we handle 27,000 cases under SARFAESI, we have seen that there are mostly errors that the borrowers are able to find, and they are able to get success in filing an application to DRT and take a kind of restraint or stay for some time. because the errors are being found in all this documentation, in all this the process of issue of notices, the contents of the notices, and the borrower's detail, what is the total amount payable, and what is the kind of asset that is intended to be enforced under SARFAESI Act. All this is the notice has to be issued by the authorized officer who is authorized by the bank. As I said, the authorized officer is supposed to be specified by the board of directors. I've seen, like in most of the cases, it is signed by an authorized officer who is not even authorized by board of directors in the case of secured creditors. So all these mistakes are normally happening. So this is the step number one. This notice has to be very clearly made, and the various judgments which are saying regarding the notice, it says that the completion of notice should be in all respects. It should not be that some of the fields are blank. The amount has to be correct. The address of the borrower has to be correct. The particulars of the property has to be very correct. And the principles of natural justice are applicable. As we have seen that the principle of natural justice is applicable to IBC proceedings also. Even in IBC, no order is being passed till the notice is being served to the other party. Similarly, in SARFAESI also, no action can be taken if the notice is considered to be served on the other party. So practically what most of the lenders are doing, they are actually serving the notice in multiple manners. They are also doing CHASPA in most of the cases, unless the borrower somehow admits that yes, the notice has been served. The notice is simply a demand notice. It does not give any right to the creditor about the property. It is simply a demand notice. So the notice has a very important impact, and that is provided in section 13, subclause 13 of the SARFAESI Act, that after the notice, whatsoever assets are mentioned in the notice, the borrower cannot transfer by way of sale, lease, or otherwise any of the secured assets which are mentioned in the notice. And in case the borrower has to do this, the borrower will take prior permission of the lender, prior permission of the secured creditor. The notice can also be given against the grantors, against the assets of the grantors which are pledged. Assets of the grantors which are pledged. So we have given the notice, and after the notice is given, after we have assured that the notice has been served, CHASPA has been done, we have seen that the borrowers have been presenting various circumstances so that they get some stay at this level also. Various litigation history is there in the last 18 years. Whenever anyone getting a notice under section 13(2), I have seen borrowers starting litigation at this stage even. So the first precaution which has been given to the banks is that at this stage, the borrower has been given a right to represent. Borrower has been given a right to represent before the lender and file objections to the notice. So borrower gives a representation and objections, and the secured creditor are under a very huge responsibility of replying to that letter or that notice where the borrower is representing or providing objections. So this communication by the bank has to be done within 15 days. These 15 days were earlier 7 days, but now it has been done 15 days. And the creditor, like the banks, have to give in writing to the borrower that whatever representation or objections that has been given by you are not acceptable to us, and they have to give reasons also why it is not acceptable to bank. It has to be a speaking order, because there are many judgments where the one-line rejection has been submitted, where the courts have held that the mind has to be applied. Whatever is being said by the borrower has to be examined, and then a spoken order has to be given. This reply is mandatory because in many cases, the banks have suffered because the reply was delayed or the reply was not appropriate. So the borrower was able to take stay from DRT or stay from many other, even other courts also. One good thing which has been decided by the court is that no appeal can be filed at the stage of this notice. When Section 13(2) is filed, at that time no application can be filed. However, the application can be filed only in case the representation or the objections are not responded by the bank. So there are many cases that we have seen so far. I have listed some of the cases in my slide: Syndicate Bank versus Basa Lingappa, Jagreet Foods, DN Motors, Titulia Coke Plant versus Bank of India, Jayant Agencies versus Canara Bank. All these are the case laws regarding the representation or objection by the borrower and the response by the banks. Now, this is out of my practical experience, what kind of objections are normally raised by the borrowers and what kind of representations are made by the borrowers. I've just listed some of them. Some might say that the limitation law is applicable. Yes, limitation law is applicable on SARFAESI law. And the borrowers might even say that the debt is time barred, so no action can be taken now. The borrower can say that the notice is not properly served. It is not served at a place where I reside. It is not served at a place where my partners reside. It is not served to all the parties. It is served with the less of documents, or it is not served. It is served on a format which is not right. The information provided in the notice is not right. So these are the various objections or representations made by the borrowers. The borrowers are normally saying that we have submitted an application for enhancement of credit facilities and the bank is not considering that. Borrowers have also been saying that there are some force majeure in that business, and because of the force majeure, they could not service the debt for some time, and they should be given some time, and that application is pending with the bank. Bank has not rejected that application. Some borrowers give a request normally to the banks for allowing operations under trust and retention account, in short, which is called TRA account. In that account, bank stipulates that whatever would be the revenue or any kind of income of the borrower, some kind of tagging would be, some kind of escrow arrangement would be made so that whatever comes to the bank as revenue of the company, some part of the revenue or the income of the company would be recovered by the bank. This is called TRA account or a tagging arrangement or escrow arrangement. Some of the objections, I have seen that the statement of the bank account is not been provided to us, so we could not verify the balance written by you. And they might even present some of the emails or letters sent to the bank for providing the statement of account. Some have taken a plea that we have submitted an OTS proposal, which has not been responded back by the bank. Some might even say that we have submitted a restructuring proposal, rehabilitation proposal, nursing proposal, which is pending with the bank, and the bank has not responded back on that proposal. Somebody will say that the property mentioned in the notice is not in the possession of the borrower. It is in the possession of somebody else, maybe on tenancy, maybe on business management. The property, maybe it's again a valid agreement of rent with someone. Somebody might even say that the stock mentioned in the notice is not even in the possession of the borrower. Most of the stock is gone to the job workers for job work. So various kind of objections that has been given by the borrowers, and it is being delaying the process of recovery by the banks. So this is the first hurdle when the borrower has been given an opportunity to represent and opportunity to be heard, opportunity to submit the objections, and in case it is not done appropriately, then the step 3 would be difficult. Now we are on step 3, which is the very, very important part, which is section 13(4) of the SARFAESI Act. This is called the measures all the secured creditors can take to recover his secured debt. So this is something which is very, very important, because I understand that the quite a big number of audience today. They are also interested in insolvency profession. If you see these measures here in SARFAESI and also the measures that we find in section 37 of the CIRP regulations, take possession of the secured asset, including the right to transfer by way of lease, assignment of sale. This is the first measure. Look at the second. Take over the management of the business of the borrower, including the right to transfer by way of lease, assignment, or the sale, realizing the secured asset. Only if substantial part of the business is held as a security interest, of course. Appoint any person, hereafter referred to as manager, to manage the secured asset, the possession of which has been taken over by the secured creditor. Require any time by notice in writing any person who has acquired any of the secured asset from the borrower and from whom any money is due or may become due to the borrower to pay to the secured creditor so much of the money as is sufficient to pay the secured debt. Now, this is what I will explain in detail to you. So the A is regarding taking the possession and selling all these assets under SARFAESI, which is the most common use of SARFAESI action. And the second is takeover of the management. And this is just like the taking over the management, managing the business of the borrower by the banks or by the managers appointed by the bank. So this B and C has not taken off. The banks have not been taking actions under this section 13, subsection 4B and 4C. What I believe is the difficulty was the infrastructure with the banks. Unlike now, the infrastructure is available in the country. We have insolvency professionals and we have complete infrastructure of monitoring them. We have a complete infrastructure of committee of creditors. However, the government tried to do this in 2002 through the SARFAESI Act, but it could not take off only because of the lack of the ecosystem infrastructure which is required for taking over the management, running the organization for some time, and then selling it to someone, or even giving it back to the borrower after the debt is paid. Now, subsection 4D says it says that the lenders, the banks, financial institutions can also give notice to all those persons who owe some money to the borrower. Means debtors, sundry debtors, receivables, advances, refunds which are due from third parties. The banks can even enforce SARFAESI action under section 13(4)(d). They can even call the money to be recovered, and they can be directed. The debtors, the receivables, the advance parties, they can be directed to make payment not to the borrower but directly to the bank in the account of the borrower, and those can be directed under the SARFAESI section. The section 13 subsection 5 also provide that the bank can even give effective receipts to receivables, to sundry debtors, when the money is being paid, when the money is paid. Now, the bank has to decide. First of all, let us go back to for this slide same. Let us say, take an example that the bank has decided for subsection A, take physical possession, or even the bank has taken the decision to enforce subsection D for recovery from the debtors. Then the step 4, the next step, which is important, is possession of the asset. So for the purpose of taking possession of the asset under section 13(4)(a), the SARFAESI Act provides that the bank's authorized officer can take assistance from chief metropolitan magistrate or district magistrate for taking physical possession. Entire section 14 deals with the physical possession. It is provided in this section that an application will have to be moved to CMM or DM. Normally, in the metropolitan cities, the chief metropolitan magistrate is there. In the otherwise non-metropolitan cities, district magistrates are there. In states, in every district there is a district magistrate, And in some of the judgments, we have also seen that the chief judicial magistrate is also empowered to give this order and to assist banks. The chief judicial magistrate is uh, available in non-metropolitan cities, whereas in the metropolitan cities, chief metropolitan magistrate is available. So we have to see in some of the cases where the DM office is not active or the DM is not very pro to giving these kind of orders, then I have seen some people approaching CJM, Chief Judicial Magistrate, and getting the orders. Now, a lot many disputes have already been settled regarding the powers of the CMM DM, what all kind of orders that they can pass. This part has actually gone into a deep litigation. There are thousands of judgments on this part. What are the powers of DM, or whether they can hold on, whether they can. But however, this has impacted adversely the implementation of SARFAESI law in the country. Now, since September 2016, now it has been made very clear by government by way of amendment that the CMM and the DM, they have to pass this order, giving the order within 30 days from the date of application. So in case for any reason which is beyond the control of the DM, the order can be given in 60 days. Now it is already, they see some of the DMs are very busy, so they are delegating these powers to the subordinate officers and for taking over the possession. So they normally appoint some Naib Tahsildar, and the Naib Tahsildar in fact assist the bank in taking the possession. So the CMM DM is also using force. The practical part of it is that when we apply to DM, the DM will see a few things, whether this there are a couple of things that have been now decided by various courts, that the DM is only supposed to see following: whether the property has been identified, whether the notice has been properly given, whether the outstanding amount has been properly mentioned, and whether everything has been given in an affidavit. So there was a great litigation. Then finally there was a judgment. In that judgment, the High Court clarified many things and also crystallized the role of DM, CMM, and based on that, complete affidavit, the contents of the affidavit is now part of the law. So when the authorized officer is making an application to DM, that affidavit has to be given, and each and every paragraph written in that affidavit also puts a responsibility on the bank that they have done this as provided in the act. So if the affidavit is there, so then the CM and DMM can give the order. This is the whenever the physical possession is taken, Section 32 of the SARFAESI Act provides for the protection of the bankers and the protection of the CMM or DM. There are chances when some incorrect property has been taken over by the bank inadvertently. So this is in case the intention is okay, in case there is no malified intention, then the DM, CMM, banks, everyone is protected under the SARFAESI Act. So these are the various experiences that we faced in taking the CMM, DMM orders and also taking the police force. So there was, earlier there was no standard documentation or standard process in various offices of CMM, DMM across the country. Everyone was asking different documents, and different kind of times were taken. Some kind of local issues, over occupation of the magistrate. So various issues at times, like we've been not getting the DM orders for years. However, since like September 2016, the time consumption for taking DM orders have been reduced substantially. We have a complete list of various districts in the country, like providing us the average time which is being taken. I would definitely name here Delhi, Ghaziabad, entire Haryana, Chandigarh, Punjab, Meerut, Saharanpur, Himachal Pradesh. We are getting the orders within 1 month now. And even various other places, we are getting these orders between 3 to 6 months, despite the act says that it has to be provided within 2 months. But still, 40% of these districts in India are still taking more than 6 to 9 months. We've seen various times that the borrower also influence the DM office. We've also seen that uh, the in case the DM says that the case is very large, the unit is very large, and there would be a lot of unemployment in case this particular factory or unit is given to the SARFAESI. In case they feel it is prone to law and order unrest, then they can refuse. Earlier they were refusing this, but now for no reason, after this amendment of September 2016, for no reason the DM or CMM can refuse. However, still they are taking some kind of local issues, like they might even say that it is a festival season. They might even say that it is a local election time, so we would not give during this period. Even the local politicians are even interfering into this process. Local politicians are saying that this kind of order should not be given in the election time. I have seen like a lot of people, a lot of borrowers, they present, or even workers, they present some kind of industrial court order or labor court order under the Industrial Dispute Act or Payment of Wages Act, and saying that the wages are not paid, payment of wages are not being given. So all this is being done by the borrower only to gain some time. So why borrowers are gaining time? Once, like in case their factory is operational, then they will try to settle with the bank and they will try to somehow get a restructuring done, or they will try to save the factory. But once they decide now it has to be given to the DM, once they feel that there is no option available now, then it would be really uh, very, very difficult for them to escape. I would actually present before you some of the examples that we have. Look at this picture. This was the factory, and this image was taken from the website of the factory regarding a factory which was operational. And the picture on the left side was taken while this unit was working, and picture on the right side is what when the SARFAESI action was invoked. This was the kind of factory, this was the kind of building was taken over by bank. See, our experience is like in India, in case there are contractors working, there are contractors who are in the business of uh, going into the any factory, any building, and they can remove anything which is sellable. So if you give a contract to those people, they will take away everything which is sellable in the market, and finally this kind of building will be left, which will be taken over by banks. And see, you believe me, even the wires of electricity wiring, switches, even the plates, everything is being removed by them, and they sell everything. So this is a very, very a kind of deep scene of how the banks are being taken for a ride, and the borrowers are not even understanding their obligations. So the various legal hurdles that in the past that we have faced, this is the practical part of it, our learning. The normally third-party tenancies created by the borrowers on the property. The borrowers normally plead that the property is not separable from other properties, and the other properties are not mortgaged to lenders. The properties are not identified by the banks purely and correctly, and the Patwari takes a lot of time in giving us the identification of the property. Normally, the family partition suits is also very big defense that is being taken by the borrowers. They normally file family partition suits or title suit of the property from third party, and they create a dispute and take an order from any court that status quo of the property would be maintained. They can even create a dispute in the family members saying that the property belongs to HUF, and they can create some nexus in the funds used in the property acquisition, which was actually the funds belonging to the ancestors. So they can say that this property was HUF property, and they can even get a decremental decree on that, So in the case of decremental decree, definitely the property would be considered as property of the HUF, and which was incorrectly mortgaged by the some member of the family. Then some of the family members, they challenge the authority of the person who is mortgaged the property, and they will create a dispute that this particular person has got no authority because he was supposed to take authority consent from the other co-partners of the HUF. Somebody say that the conveyance deed is defective, the conveyance deed is duplicate, multiple mortgage cases, and also somebody raised the issues of service of notice was not done correctly. The claim amount of the lenders was challenged, limitation period was challenged, property details was not correctly provided, NPA classification was not correctly done. The objections and the representation given by the borrower was not responded. It was not the order was not spoken, and the borrower has made some payment after the notice. So this is also being used as a very big way. After the notice, borrowers will make some payment to the bank, and then they will say that the amount mentioned in the notice is not correct. OTS proposal is under consideration by the bank. So any other thing which the banks and the banks have been facing while taking the DM order. These are various practical experiences that we have when the borrowers actually buy time in using any of these in their cases. So the legal understanding of the physical possession has been very clear in various judgments. The lender would not become owner of the asset after taking the physical possession. The physical possession doesn't mean that the bank has become the owner. Taking possession does not mean transfer of title. Possession is only for realization of the security interest and not for the use. No banker can say that I have taken the possession of the property and I will start my office. The bank will start its branch from that office. It is not possible unless the bank adjusts the value, unless the bank buy the property itself and adjust the value account in that adjust the sale price in the account of the borrower. The lender will only act as a receiver till the asset is sold, and the lender will take care of the asset very well, as if the care is taken by the owner. It has been held by the court that the reasonable force is permitted while taking the possession. So when the police goes on, with us for taking physical possession, the police definitely use force, and the courts have also held that reasonable force is permitted. Even after taking the possession, the benefit from the asset would go to the borrower's account. Now, this is very, very important. In case we take physical possession of the property, and any small part of the property or whatever is generating some income, and that income would still accrue to borrower, that income would not accrue to bank. I mean, even if it is going to the borrower's account in the bank, but it will actually accrue to the borrower. And they see various litigations in the DMM order taking process, which has been almost settled now because of various Supreme Court judgments. The various litigations say that the role of the CMM DM is merely to assist in taking possession. Either merits or rival contentions of parties are not within the scope of the powers. Second, the role of DM is purely executionary, no adjudication required, has been held in 2 cases. The CM is supposed to verify 2 aspects: whether the secured property is identifiable, whether the secured asset falls within his territorial jurisdiction, and whether the notice under section 13.2 of the 13.2 of the SARFAESI Act is given or not. No adjudication of any kind is contemplated at this stage. DM is not empowered to decide the question of legality and the propriety of any of the actions taken by the secured creditor. The no adjudication of the nature of the land or of the question of whether any dues were payable or whether the payments were made by the borrower to the bank, that was also considered as not part of the DM order. DM cannot entertain disputes relating to the jurisdiction of the secured assets. One judgment, like as I was referring to, this is the judgment K.R. Chandrasekharan and others versus Union of India. In this judgment, double bench of Madras High Court, in fact, passed a very, very detailed order regarding the guidelines for CMM DM orders and their powers, and what are they supposed to see. while they are giving this order. So based on this judgment, an affidavit was the contents of the affidavit was drafted, and finally it became part of the SARFAESI Act. Now the contents of this affidavit is there in the SARFAESI Act itself. It actually originated from this. So now the DM issue is over. So we are now going ahead with the issue of the tenant and landlord. So this has been a very, very big hurdle for the banks in recovering the security interest, enforcing the security interest. And this has been a very, very successful kind of rescue for the borrowers. Because this has never been challenged so far. Even if there is a tenant, even if the tenant is on unregistered lease agreement, even if the tenant is sitting there without an agreement and there is an evidence of payment of rent, the tenancy has been considered as over and above SARFAESI Act. Anyone who is in the occupation of the property, whether the permission of the banks were taken or not, whether it was mentioned in the documents that the borrower will not give the property on lease or hand over the possession to somebody else. However, the right of the tenant has been protected in various litigations on this account. It has actually been held that the CMM and DM has no power to pass an order to evict a tenant. However, in case the tenant evicts, in case the tenant surrenders the property willfully, then nobody can ask a question. See, even if the tenancy is not valid on account of stamp duty, on account of the registration, still the law of natural justice has been upheld, and the DM are not supposed to pass an order of evicting the tenancy. However, one good part which was done by the central government, like in case of tenancy disputes where the SARFAESI is applicable, so wherever the SARFAESI is invoked, and after that, in case there is any tenancy dispute, the tenancy dispute will not go to the rent control court. It can be settled by DRT, and even in some cases it can be settled by the DM also. So it has been held that the non-registration of the lease agreement does not render the tenancy nugatory. The attention must be paid to the relationship between the parties. Now, in case the lease is created between father and son who are staying in the same property for the last so many years, that has to be seen. It has to be a arm's length transaction. The documentation is not really very, very important. The transaction has to be an arm's length transaction. The fact that there was a regular payment of the rent is also very important. So no undue advantage can be taken on the basis that the lease deed is unregistered. So this was the dispute on tenant and the tenant occupation on the property, which is a secured asset with the creditor. Now this dispute, the other dispute that now I am trying to share with you is the dispute of symbolic possession, or we call it constructive possession, and physical possession. So there were many disputes regarding this. There were disputes to that extent that Punjab and Haryana High Court came with a judgment which says that there is no need to take physical possession. Bank should only take symbolic or constructive possession and sell the asset, and later they can take the physical possession. However, now the rules were amended on 17th October 2018, not very far. Appendix 4A and Appendix was created. In fact, Rule 8.1, Rule 8.2, Rule 8.3. Now it is seen, it is very clear that the physical possession may be taken, physical possession may not be taken. The property can be taken even after taking the symbolic or constructive possession. And even after the issue of the sale certificate, the physical possession can be taken under Section 14. So that can also be done later. So that's a clarity now and the clarity has been to a great extent now, especially in the case of Transcore versus Union of India. The Supreme Court has held it that symbolic, constructive, or physical, it is almost the same, and there is no difficulty. Like this, see, if we see this judgment, where the Kerala High Court has said very clearly in a Kotakal Cooperative Urban Banks Limited versus Balakrishnan, and it was held that in terms of Section 13(6), there is no legal or jurisdictional error in the sale being held by the secured creditors on the strength of the de jure possession, means symbolic possession. It also held that where the secured creditor has completed transfer on the basis of de jure, possession is entitled to apply for assistance to CMM DM to take de facto possession of the security interest. So I would refer to my co-organizers. To Ankit Goel. Ankit, is there any questions which you feel that I should answer now, or I should continue with the presentation? Ankit, are you hearing me? Ankit, can you listen me? Okay, so maybe that.
Just a second. So I was fine. So basically there are questions, and we can actually take up the questions, which will be helpful to keep everyone involved and answer their questions side by side. Also, perhaps the some settled laws in SARFAESI, which you think may be applicable to IBC, may also be mentioned, so that those who have IBC as their core practice can also
So see,
relate
like
to.
as I said, Ankit, as I said in the beginning, that this will be chapter 1 and the chapter 2, because the SARFAESI, unless everyone will understand SARFAESI completely, it will be very difficult to correlate to both, and also especially for the banks. See, when they have to decide uh, which action is appropriate for a particular case, it actually has to be seen that the complete SARFAESI is now settled. There are apprehensions that were there in the uh, uh, market with the stakeholders, that there is a lot of litigations are going on, and still there are a lot of issues which are not settled. Why I'm trying to say again and again is like the DM issue is settled, the physical possession, symbolic possession is settled, agricultural issue is settled. See, like what are the kind of security interests, secured creditors, all this is settled. So the practical difficulties, the practical shelters that the borrowers were taking, all those are getting settled. So this clarity has to be given before actually we start comparing it with the insolvency and bankruptcy code. See, as I said to everyone, that I have prepared a detailed analysis of the 27,000 cases that we've handled, and we have categorized into 6 categories based on similar facts. And for each and every category with similar facts, we would see if we take up action under SARFAESI or under insolvency, what would be the pros and cons. And then it will be very comfortable for everyone to understand, because till the time SARFAESI is also given, I would do it quickly. Or if there is any question on the SARFAESI, Ankit, or is there a
So
question on IBC?
I'm asking some questions. I'm just picking the ones that seem to be important, more important than that the others. Almost all questions are relevant questions. So one of the questions is with respect to symbolic possession, and how the symbolic possession, how the bank can sell the property after symbolic possession, and the duties of the bank before in the physical possession process after the property is auctioned.
No, it is very clear, because I actually said I go back to the same the dispute regarding the physical possession and the. So this is very clear now. The even Supreme Court has said very recently that it is not important that the physical possession should be taken. Even the banks can take, when banks can sell the property on symbolic possession, and after the sale certificate is issued, they can still file an application to the DM, take a police help, and they can take the physical possession of the property and hand over to the buyer. So it is very clear now that even after the sales certificate is issued, the bank can file an application to DM, and then the DM can give them the police force, physical possession can be taken. So the process will be the same for taking DM order, application, affidavit, but then whatever time is taken by the DM and the police help, that would be the only time which the buyer will have to wait in this case.
Then we have another question where a few people amongst us perhaps are valuers, and they're asking the role of valuers in the SARFAESI process.
See, the valuer is defined in the rules, and it actually is very, very clear that the valuers, as defined in the rules, are still the valuers of the valuers which are registered under Section 34AB of Wealth Tax Act and approved by the Board of Directors of the bank. So what is the mandate under the SARFAESI Act is that any valuer who is registered as a valuer under the Wealth Tax Act and is also approved by the Board of Directors of the bank. So these are the valuers who would be valuing. I think, but now what we are discussing is it is only short-lived, because now, Ankit, you can even say better, with the new bill which has come, where this the separate institution would be made. Can you just answer this question? Because see, once we say that this.
So there is a valuer bill 2020, which is basically part of a 179-page report from IBBI. IBBI was given the task of looking into the process of, or looking into the whole framework, how the valuation profession can be created and can be encouraged in India. So the objective of that bill and the full report is to bring more, I would say, reliability on the work of valuers, request them to follow valuation standards, and make it a regulated profession so that India can become an export house for valuation work across the globe. And currently, if we see the IBC process and SARFAESI process, or even new loan process, sometimes we struggle with genuine valuations for various properties. So that is what that bill is attempting to resolve.
So I think that would be also all these valuers who are registered under Wealth Tax Act, they would also be enrolled by this valuer bill, and they would also become valuer. They would also become part of that institution which is proposed by IBBI now.
They will go through the process of the examination that IBBI has been conducting for registered valuers under IBC and Companies Act, and they have a transition time of about 2 years wherein they can make this transition.
So, Ankit, is there any other important question which I can answer? Otherwise, I would like to finish this SARFAESI today, so that we.
I think you can go ahead. You can go ahead, and maybe in the forthcoming session, we will be able to answer the questions as well, and we will anyway share the answers to all these questions with everyone.
Yeah, we'll provide the answers to this, and maybe that tomorrow, that repeat session that we are doing. So in that repeat session, we will try to answer some of the questions. Today it was a kind of a very, very lengthy presentation that I have prepared, and also when we'll have tomorrow, we'll have some other organizers for understanding questions and putting across and discussing. So we have collated our practical experiences of taking physical possession, and so far in our company we have taken more than 5,000 physical possessions. And what all experiences that we have seen. One, like while we are going for the property physical possession, the property is not properly identified. Police force is not cooperating because there are locks, and the police force doesn't want to break the locks because they need some different process for breaking the locks. Police force is less in number or in power as compared to the borrower's family, friends, and the workers. The borrower has been taking various stays from the courts on various grounds, and we have seen a lot of resistance from the workers while we take physical possession. And in fact, practically, I may tell you that wherever somebody like some maybe more than 200, 300 workers are already working and the unit is in operations, the success rate under SARFAESI is very, very low. And even the banks are also not interested that this kind of factory should be taken over and the complete the operations are closed. That is also something which is not really liked by the banks. In some of the transactions that we have seen, that the bank take physical possession of the property, they put their own security, and they hand it over back to the promoters again for continuing the operations. So then it is considered as it's a symbolic possession or it's a physical possession. However, the same promoter is going and conducting the business every day. The pending disputes with the workmen, some attachment orders, there's some when we go for the physical, then we actually can see that some PMLA attachment is there, ED attachment is there, income tax attachments are there, attachments from the worker courts, industrial dispute courts. There are various attachments that we see, so we actually come back unless that attachment is handled, because the SARFAESI Act is not empowered that every attachment is not automatically detached. Borrower normally rushed whenever we plan for physical possession. Borrower rush to banks and they try to do some settlement. They try to pay some money to the banks, and the banks direct us not to do that today. In the case of large units where the operations are running, huge workforce, large areas, local leaders, police at times is not interested because of the huge loss to that city, to that town. These are the various difficulties that we face under the SARFAESI Act for taking possession. Now we come to a scenario: purchase of property by a secured creditor under the SARFAESI Act. This was again a concept that I wanted to discuss, as I touched this subject a little bit, that the physical possession is for uh, realizing the property value, and the physical possession is not for using the property. In case the secured creditor has to use the property, they have to buy it. They will fix a reserve price, and then they can bid for the property. And in case the purchase price will be adjusted with the amount of claim. So this is very, very important. Like I see, whenever the banks purchases such property, then Section 9 of the Banking Regulation Act is applicable, and which says very clearly that the bank will not be able to sell this property for 7 years at least. This is what Section 9 of the Banking Regulation Act says. This is the reason that the most of the properties are not being purchased by the bank. I will just take half a minute break, just half a minute. So the property can be purchased by the bank, but then that process has to be followed. And then after the bank purchases that property, it has to be held by them for at least for 7 years. Now we come to the main part, which is the sale of secured asset by the creditors. This is the final part, which is the how the sale has to happen. So any asset which is sold by the bank and whatever money is realized, it has to be distributed. Under section 13(7), it would be distributed again like insolvency law. First, it will be the first part would be used for all the costs, charges, expenses on sale, preservation of the asset. Because see, when the asset is taken over by the bank also spends a lot of money in the preservation and protection of the asset, like security guards, and even like insurance, and other various charges for publicity for the sale, and for the money that they pay to all these enforcement agents and resolution agents. So all that is chargeable from the proceeds. Then secondly, the money would be paid to the secured creditors, and the third is the balance would be paid to the person. Like in case this total property is say 10 crores, and the sale proceeds are 10 crores. Out of the 10 crores, only the bank is having a total outstanding of 8 crores. So the balance 2 crores minus the cost of sale, everything that will go, that money will go back to the borrower. This is what the law is. So in the case of liquidation, this will be the amount. In the case the company is in liquidation and the asset is enforced by the under the security, as it will be distributed as per the section 529 of the Companies Act. So what is that? So during the liquidation or winding up proceedings, also the banks can prefer that they would they would sell their asset themselves, would not give it to the official liquidator. So the bank will sell the assets, recover their money. They will not relinquish their security interest in favor of the official liquidator, and then they will realize, and they will retain the sale proceeds after depositing the workman dues. Okay, there are various orders that the banks have to give workman dues to official liquidator or to the workman. There are orders that the money actually would be kept as a trustee. See, whenever an asset is sold, the bank will have to keep the money as a trustee till the time it is distributed as per the law. See, the sale cannot be made if the amount of dues is standard. This is also section 13(8) is very clear that in case we are not, see, in case we are in the process of selling, then we are just very close to selling the asset. Before even the sale of asset, before the date of publication of notice for public auction, before inviting quotations or tenders from the public, before even finalizing a private treaty between any buyer and the bank, if the amount is tendered by anyone in that account, the process of sale has to be stayed immediately. So this is the last effort which is normally made by the borrower, because at that last stage, somebody would come and say that I am depositing something today and the balance I would deposit in some other days. So some of the courts are giving some kind of relaxation in case substantial money is deposited. Like in the case of insolvency, 66% voting share is required for any major action. Similarly, in the case of SARFAESI also, in the case of consortium financing, in the case of all those pari passu charge holders, 66% of those creditors who are holding pari passu charge on an asset, they would agree for any action under section 13(4), then that action will be taken. Maybe for sale, maybe for taking possession, maybe for management of the company, everything. So this is the sale process. The secured creditor can file an application to DRT for recovery of the balance amount. Recovery of the balance amount means, like in case this is the example I gave, 10 crores the value of the asset, 8 crores is the total outstanding. Now if I change the illustration, 10 crores is the value of the asset and 12 crores is the total outstanding. So I will appropriate 10 crores, and for the balance 2 crores, I will actually file an application to DRT for recovery from the borrower entity and also from the grantors. So this is a management takeover part, which of course has not been effective. I'm only trying to tell you, like, this kind of endeavor was made by central government in 2002 also, that the management of the business can be taken over. And it again, like, it provides the complete setup. Notice would be given in newspaper, The bank will appoint their own directors. They will appoint an administrator for the business. The existing management and the directors shall be deemed to have vacated their offices. Any contract of management between the borrower and the director shall actually be terminated. The newly appointed directors will have all the control and custody of assets and the business of the borrower. All the powers would be exercised by the new appointed directors. Shareholders can also appoint one of their directors in such managed companies. However, these shareholders would not be able to take any decision without the approval of the secured creditors. So in this case, in case the takeover has been taken by the management, then the winding up also would not happen. These companies would be protected for winding up cases. See, like, but then the case, like in case of this management has been taken over, but then in case the debt is paid, then the management will be restored to the borrowers. The banks, it is also provided in this section 615 that the bank can even convert their debt into shares. But once it is done, then the unit cannot be given back to the management back. When the directors are ousted from the company, there is no compensation would be payable to them. So similar provisions are also available in the first part of SARFAESI. And I've seen, I think I still know some of the ARCs, they are doing it. They actually are taking over the companies, they are taking over companies and they are managing it. And they are managing full way and with the even the existing directors or without existing directors. So in that manner, the RBI has also given a policy, a complete guidelines, which is called change in or takeover of the management, change in or takeover of the management of the business of the borrower by securitization companies and reconstruction companies, Reserve Bank Guidelines 2010. And later it was consolidated in the Master Circular dated 2nd July 2010. However, no such guidelines were issued by RBI under section 13(4)(b) for the management and takeover of the secured creditors. I have not seen the banks are taking action under this section. Maybe the reason, I have analyzed some of the reason. One, that who will manage the borrower's company? Who will run the show? Who will become the directors on the company? Who will be the administrator? Who will fund the continuous losses? Who will pay salaries to the workmen? So all these questions were not answered. RBI did not come with a policy. So there was no guidance. The banks also had no policy of taking over management like this. Okay, so now this management has been done. So once all this is clear, we've seen like first step, second, third, fourth, whatever action that we have seen. There is a power of appeal. Like whenever anyone is aggrieved, there is an application possible which can be filed to DRT under SARFAESI action, SARFAESI under Act. So any cause of action, any possession, any action taken by the borrowers can be challenged by filing an application before DRT. And that application has to be within 45 days of the action or measure taken. No application can be filed if the representation or objections are not accepted by the secured creditor, because that of course was taken away because a lot of litigation was going on. That is not appealable. Jurisdiction lies at the cause of action, location of the asset, branch, or the office, because the DRT of that location would have the jurisdiction. DRT will consider if any measure have been taken without following the provisions. If found that the measure has, the provisions have been applied without taking all the precautions, then the order would be confirmed. In case it has been complied with, in case the complete process has not been complied with, then the entire process can be reversed by a DRT. That also is possible. But the DRTs were not there in Jammu and Kashmir. So in Jammu and Kashmir state, this power was given to the Court of District Judge.
The audience will perhaps like to understand the audience will like to perhaps understand the time till which we will continue, so that they can perhaps plan accordingly.
I think we'll only have more 5 minutes. I think 5 minutes, and then we'll see some of the questions. So there is an appeal theory again. Like I would like to share with you that in both these provisions, like Section 17 and Section 18, the even SARFAESI Act during 2002, they had a timeline. it was provided in the timeline, it is still there in the timeline that all these DRT applications would be disposed of in 60 days. And in case they are not able to dispose of in 60 days, then they will seek extension by given reasons in writing. And maximum provision which is time is given there is 4 months in disposing of any application by DRT. So that is there in the provision, but that is also not being it's not in use because the timeline of the DRTs are not very comfortable as of now. So the appeal can be filed within 30 days, but however, this appeal is very, very difficult nowadays. Any order of the DRT, and in case somebody has to file an appeal, there is a requirement of 50% of the debt has to be deposited before the appeal can be heard. Only DRAT has power. Only DRAT has power to reduce the amount to 25%, and that also by just recording the reasons. Otherwise, the filing an appeal before DRATs has become very difficult because the debt, 50% of the debt has to be deposited. The very, very recent amendment I should share with you, because this amendment to SARFAESI Act 2002 was also done on 26th of December 2019, which I said that the SARFAESI was implemented. SARFAESI was implemented with effect from 24th of January 2020. The 3 sections of section 17, 18, 19 were notified, and this is regarding the filing of the transactions of securitization, reconstruction, and creation of security interest. What we are interested as of now is the creation of security interest, and the creation of security interest transactions are supposed to be submitted to SARFAESI with effect from 24th of January 2020. Of course, like as I said, that this SARFAESI was implemented in 2011. All the banks and financial institutions, they were filing their transactions to SARFAESI. They were submitting all the transactions of creation of mortgage to SARFAESI, and the SARFAESI was completely in operation. However, now the conditions have been very, very stringent. From 24th of January 2020, the banks will not be able to take any action under SARFAESI if the transaction has not been registered with SARFAESI. That's a very, very stringent part of it. The filing process has been given completely, how the filing has to be done, filing by the banks to SARFAESI. So the very, very important implication of the filing, which is there in section 26D of the SARFAESI Act. From the date of appointment as notified is 24th January 2020, no secured creditor shall be entitled to exercise the rights of enforcement of security interest under SARFAESI Act unless the security interest is registered with SARFAESI. So now there are 2 situations that we are seeing. One, that each and every mortgage, each and every charge, each and every hypothecation is now registered with the SARFAESI. In case not registered, then the banks, financial institutions, and NBFCs would not be able to take any action under SARFAESI Act. Section 26E, after the registration of the security interest with SARFAESI, the debt of the secured creditor that the banks, financial institutions, NBFCs, ARCs shall be paid in priority over all other debts and all revenue, taxes, cess, other rates payable to central government and state government. So this scenario is now almost equal to IBC. If your property is registered, if your transaction is registered with SARFAESI, then even if you invoke SARFAESI, then the charges of income tax, any state government, central government, or any other local authority would not be having any priority. The priority would be given to the secured creditor, just like IBC. So this is just happened now. It happened only on 24th of January 2020. If the IBC proceedings are pending in respect of any secured asset, the priority, of course, will be as per IBC. Otherwise, it will be as per. So, like now, I think we have lot many Supreme Court judgments, which the ratio of all these Supreme Court judgments has already been discussed with you. We have finished it on time as far as the SARFAESI part is concerned. The other part that I have with me is a detailing about the process. What would be the content? I mean, that's of course is not supposed to be discussed here. And since we are discussing with the most of the learned people, so that is for operational purposes, that what kind of notice, what kind of formats, what kind of appendix is to be applied in each scenario. So friends, the present today we have presented only SARFAESI to you, and the IBC, of course, has been discussed amongst many because most of the stakeholders would understand IBC. When I would discuss IBC, I would only discuss IBC at because this is a subject of a subject in vogue. Most of the people are keeping updated, whereas the SARFAESI is new for many. I thought that for SARFAESI it is important that I should go in detail. However, for IBC, I will only see most of those cases, most of those provisions which are either different or similar to SARFAESI. Then I would actually analyze my situation. Like I would then say, this is the analysis of all these cases that we are handling, and in each case, how the decision can be taken. That is a combination of experience of SARFAESI and combination of experience in IBC. Under IBC also, we are handling 153 cases. We are 42 partners, and all that experience has been combined in that analysis. That actually would be given in chapter 2 of this webinar series. Chapter 2 will come. Chapter 2 will be there on Wednesday at 4 p.m. and registration will open after this session is over. So I would prefer that most of those who have participated today, so for the complete clarity of SARFAESI and IBC, and most of my banker friends, so they would definitely use it in their decision making. And not that they don't know it, but it is basically a kind of updation of a subject, which actually would be having SARFAESI and IBC, and then how the decisions can be taken. So
I can perhaps I can perhaps add that there will be a repeat session of today's session tomorrow at 11:30. Anyone who had a problem with the audio or anything at all, any technical issue, can join tomorrow. We don't know the expected number of participants for tomorrow's session so far, but if the participants are lesser in number, maybe we can take in more questions tomorrow on a live basis.
See, with this session that we will conduct tomorrow also depends upon because we have seen the audience, we got the registrations of more than 1,357, and that also because it was closed, otherwise it could have crossed 2,000. So tomorrow also some people who actually could not participate because of some other assignment, because I understand there is another webinar by ICAI IPA. So that is also one of the reason because there was a clash and it was reported to us by some people that there is a clash. Then we opted for another session tomorrow morning, and that would be a repeat session. So even after that, we'll see in case we are able to upload this video on YouTube channel of AAA Insolvency. So Ankit, is this because already this is the 6:13? We are 15 minutes ahead because we waited initially for about 7-8 minutes, 10 minutes. So in case there is any question, we are right on time.
We can take up the questions perhaps and basically share the answers to all the questions collectively.
Yeah.
There are a lot of questions, but answering them at this point in time may not be feasible, all of them at least.
So I think thank you very much, participants, and I was overwhelmed with the response that you have given. I will take it as a motivation to me for sharing my experiences and work hard in spreading the market is definitely for SARFAESI and IBC. I will spread this experience of mine, share with everyone, and this is also my way of learning. Thank you very much. Thank you very much. I wish everyone have good evening, and I'll keep meeting you. I'll keep meeting you all again and again. Thank you very much. Thanks a lot. It is really wonderful. Thanks. Can you close it, Uncle? Yeah, should I close it?